Good morning. Though people used to speak a lot about discrimination and particularly concentrating the upliftment of tribal women, tribes, but there are multi number of cases, incidents, statistics report that several village tribes were not properly attended. Recently, slowly they are getting some relief, and tribal women are also coming and reaching high peak participation in the society. When Hindu Succession Act, Hindu Marriage Act, everything was enacted, and they have simply said that the rights of the tribal will be under personal laws is based upon the customs and usage. But here the Supreme Court has step ahead in doctrine of ruling out principles, categorically held by extending the Article 14, gender equality, that the plaintiffs are entitled to equal share in the property of their maternal grandfather. Such a thing was there. A man left out five daughters and five sons and one daughter. Five sons and one daughter. So the left out daughter filed suit for partition, but the lower court has rejected, stating that you have not proved the customs under which you can seek partition and the right of succession. Then first appeal court confirmed, second appeal court also confirmed, but the Supreme Court has categorically discussed about one concept, that is principle of justice, equity and good conscience. So they have also discussed about Central Provinces Laws Act 1875, Section 6, which was subsequently repealed by 2018. And therefore, when there is clear provisions, the Section 6 of the Central Provisions Act facilitate to apply this principle of natural justice, justice, equity and good conscience. But however, the Supreme Court has categorically held by discussing multi number of judgments. In AR 2025 Supreme Court 3356, AR 2025 Supreme Court 3356, Ram Charan and others versus Sukhiram and others, therein they have categorically held there is no rational nexus or reasonable classification for only males to be granted succession, more so in case where no prohibition to such effect can be shown to be prevalent as per law. So Article 14 includes aspects of gender equality, considering the principles of justice, equity and good conscience, along with the overarching effect of article. Plaintiffs are entitled to their equal share in property of their maternal grandfather. So they have discussed about history is available at paragraph 4. Then other observations that see, to emphasize the principle of justice, equity and good conscience, multi number of judgments were discussed at paragraph 18, which you have to go through that. Then question of 1875 Act, which provides Section 6 and subsequently repealed, and that repeal act saving some provisions by going through that paragraph 16, you can understand the judgment. They have also discussed about Maneka Gandhi versus Union of India, wherein Article 14 was discussed. Paragraph paragraph 18, paragraph 18, they have discussed about Siddiq versus Suresh Das Ram Janmabhoomi case. All these things are there. Kindly go through this judgment if you are really interested to understand this concept of justice, equity and good conscience, and Article 14. How these judgment, these provisions played prominent role in these cases, and they have also relied Jammu Kashmir versus Triloknath Kosa. So many cases. Go through if you want to know deep knowledge about that. Best wishes.